In episode 5 of the Supreme Court Opinions Read podcast, I'll be reading the Supreme Court's opinion in TikTok versus Garland. The case was decided January 17th, 2025. And as always, we begin with the syllabus. TikTok is a social media platform with more than 170 million U.S. users. While TikTok Inc. operates the platform in the United States, its ultimate parent company is ByteDance Limited, a privately held company with operations in China. ByteDance Limited owns, develops, and maintains the proprietary algorithm TikTok uses to generate a personalized content feed for each TikTok user. Under Chinese law, ByteDance Limited is required to assist or cooperate with the Chinese government's intelligence work, and the Chinese government has the power to access and control private data the company holds. Government officials in the United States have taken repeated actions to address the national security concerns regarding the relationship between China and TikTok. Against that backdrop, Congress enacted, with broad bipartisan support, the Protecting Americans from Foreign Adversary Controlled Applications Act. The act makes it unlawful for any entity to provide certain services to distribute, maintain, or update a foreign adversary controlled application in the United States. Such applications expressly include any application that is operated directly or indirectly by ByteDance Limited or TikTok. The Act's prohibitions as to those applications are effective beginning January 19th, 2025. See Section 2A2. The Act provides, however, that TikTok can avoid the Act's prohibitions by undergoing a qualified divestiture, one the President determines will result, among other things, in the application no longer being controlled by a foreign adversary. ByteDance Limited and TikTok, along with two sets of TikTok users and creators, filed petitions for review in the D.C. Circuit, challenging the constitutionality of the Act. As relevant here, petitioners argued that the Act's prohibitions, TikTok-specific foreign adversary-controlled application designation, and divestiture requirement violate the First Amendment. The D.C. Circuit denied the petitions, holding that the Act does not violate petitioners' First Amendment rights. The court granted certiorari to consider petitioners' First Amendment challenges on an expedited basis. Held, the challenged provisions do not violate petitioners' First Amendment rights. Part A. The court first considers whether the challenged provisions are subject to First Amendment scrutiny. Laws that directly regulate expressive conduct can, but do not necessarily, trigger such review. See RAV versus St. Paul. The court has also applied First Amendment scrutiny in cases involving government regulation of conduct that has an expressive element, and some statutes which, although directed at activity with no expressive component, impose a disproportionate burden upon those engaged in protected First Amendment activities. The court assumes, without holding, that the challenged provisions are subject to First Amendment scrutiny. It is not clear whether the Act directly regulates protected expressive activity or conduct with an expressive component. Indeed, the Act directly regulates ByteDance and TikTok only through the divestiture requirement, and it does not regulate the creator petitioners at all. In any event, petitioners' arguments more closely approximate a claim that the challenged provisions, which in effect will ban TikTok in the United States, disproportionately burden petitioners' First Amendment activities. The court has not previously articulated a clear framework for determining whether a regulation of non-expressive activity that disproportionately burdens those engaged in expressive activity triggers heightened review, and does not do so in these cases. The court instead assumes, without deciding, that the challenged provisions fall within this category. Part B. The challenged provisions trigger only intermediate scrutiny. Section 1. Content-based laws, those that target speech based on its communicative content, are presumptively unconstitutional and may be justified only if the government proves that they are narrowly tailored to serve compelling state interests. Content-neutral laws, in contrast, are subject only to intermediate scrutiny because they generally pose a less substantial risk of excising certain ideas or viewpoints from the public dialogue. Under that standard, the court will sustain a content-neutral law if it advances important governmental interests unrelated to the suppression of free speech and does not burden substantially more speech than necessary to further those interests. The court has identified two forms of content based speech regulation. First, a law is content based on its face if it applies to particular speech because of the topic discussed or the idea or message expressed. Second, a facially content neutral law is nonetheless treated as a content based regulation of speech if it cannot be justified without reference to the content of the regulated speech or was adopted by the government because of disagreement with the message the speech conveys. Section 2. The challenged provisions are facially content neutral. They impose TikTok specific prohibitions due to a foreign adversary's control over the platform and make divestiture a prerequisite for the platform's continued operation in the United States. They do not target speech based upon its content or regulate speech based upon its function or purpose, nor do they impose a content based restriction, penalty, or burden. Petitioners argue that the act is content based on its face because it excludes from the definition of a covered company any company that operates an application whose primary purpose is to allow users to post product reviews, business reviews, or travel information and reviews. But that exclusion does not apply to the Act's specific designation of TikTok as a covered application. As such, the exclusion is not within the scope of petitioners' as applied challenge. Section 3. The government only supports the challenged provision with a content neutral justification, preventing China from collecting sensitive data from 170 million US TikTok users. That data collection justification neither references the content of speech on TikTok nor reflects disagreement with the message such speech conveys. Because the justification reflects a purpose unrelated to the content of expression, it is content neutral. Section 4. The Act's TikTok-specific distinctions, moreover, do not trigger strict scrutiny. While laws favoring some speakers over others demand strict scrutiny when the legislature's speaker preference reflects a content preference, such scrutiny is unwarranted when the differential treatment is justified by some special characteristic of the particular speaker being regulated. Here, the challenged provisions regulate TikTok based on a content-neutral data collection interest, and TikTok has special characteristics: a foreign adversary's ability to leverage its control over the platform to collect vast amounts of personal data from 170 million US users that justify differential treatment. Part C. As applied to petitioners, the Act satisfies intermediate scrutiny. Section 1. The challenged provisions further an important government interest unrelated to the protection of free expression. The Act's prohibitions and divestiture requirement are required to prevent China, a designated foreign adversary, from leveraging its control over ByteDance Limited to capture the personal data of US TikTok users. This objective qualifies as an important government interest under intermediate scrutiny. TikTok collects expansive personal information from and about its users. Access to such detailed information about U.S. users, the government worries, could enable China to track the location of federal workers, build dossiers for blackmail, and conduct corporate espionage. Rather than meaningfully dispute the scope of the data TikTok collects or the ends to which it may be used, petitioners argue that it is unlikely that China would compel TikTok to turn over user data for intelligence purposes. The court, however, affords the government's informed judgment substantial respect in the national security and foreign policy contexts. The government's determination that China might leverage its relationship with ByteDance Limited to access U.S. TikTok users' data is at least a reasonable inference based on substantial evidence. The court also rejects petitioners' argument that the Act is under-inclusive as to the government's data protection rationale. On this record, Congress was justified in specifically addressing its TikTok-related national security concerns. Section 2. As applied to petitioners, the Act is sufficiently tailored to address the government's data collection interest. Intermediate scrutiny is satisfied if the challenged regulation promotes a substantial government interest that would be achieved less effectively absent the regulation and does not burden substantially more speech than is necessary. That standard is met here. The prohibitions account for the fact that, absent qualified divestiture, TikTok's very operation implicates the government's data collection concerns, while the requirements that make a divestiture qualified ensure that those concerns are addressed before TikTok resumes U.S. operations. While petitioners offer a series of preferred alternatives that they assert would equally address the government's data collection interest, those alternatives ignore the latitude the court affords the government to design regulatory solutions to address content neutral interests. The court will not override the government's judgment respecting content neutral regulations so long as the government's policy is grounded on reasonable factual findings supported by evidence that is substantial for a legislative determination. Those requirements are met here. Part D. Beyond data collection concerns, the government asserts an interest in preventing a foreign adversary from controlling the recommendation algorithm that runs a widely used U.S. communication platform and from wielding that control to alter the content on the platform in an undetectable manner. In petitioners' view, that rationale is a content-based justification that triggers strict scrutiny. Petitioners have not pointed to any cases in which the court has assessed the appropriate level of First Amendment scrutiny for an act of Congress justified on both content neutral and content based grounds. They assert, however, that the challenged provisions are subject to and fail strict scrutiny because Congress would not have passed the provisions absent the foreign adversary control rationale. The court does not determine the proper standard here. Even assuming the government has offered a content-based justification for the challenged provisions, petitioners' argument fails under the standard they propose. The record before the court adequately supports the conclusion that Congress would have passed the challenged provisions based on the data collection justification alone. And now on to the opinion, which was written per curiam. As of January 19th, the Protecting Americans from Foreign Adversary Controlled Applications Act will make it unlawful for companies in the United States to provide services to distribute, maintain, or update the social media platform TikTok unless U.S. operation of the platform is severed from Chinese control. Petitioners are two TikTok operating entities and a group of U.S. TikTok users. We consider whether the act as applied to petitioners violates the First Amendment. In doing so, we are conscious that the cases before us involve new technologies with transformative capabilities. This challenging new context counsels caution on our part. As Justice Frankfurter advised 80 years ago in considering the application of established legal rules to the totally new problems raised by the airplane and radio, we should take care not to embarrass the future. That caution is heightened in these cases given the expedited time allowed for our consideration. Footnote 1. Applications for an injunction pending review were filed on December 16, 2024. We construed the applications as petitions for a writ of certiorari and granted them on December 18, 2024, and oral argument was held on January 10, 2025. Carrying on. Our analysis must be understood to be narrowly focused in light of these circumstances. Part 1, Section A. TikTok is a social media platform that allows users to create, publish, view, share, and interact with short videos overlaid with audio and text. Since its launch in 2017, the platform has accumulated over 170 million users in the United States and more than 1 billion worldwide. These users are prolific content creators and viewers. In 2023, US TikTok users uploaded more than 5.5 billion videos, which were in turn viewed more than 13 trillion times around the world. Opening the TikTok application brings a user to the For You page, a personalized content feed tailored to the user's interests. TikTok generates the feed using a proprietary algorithm that recommends videos to a user based on the user's interactions with the platform. Each interaction a user has on TikTok, watching a video, following an account, leaving a comment, enables the recommendation system to further tailor a personalized content feed. A TikTok user's content feed is also shaped by the content moderation and filtering decisions. A TikTok user's content feed is also shaped by content moderation and filtering decisions. TikTok uses automated and human processes to remove content that violates the platform's community guidelines. TikTok also promotes or demotes certain content to advance its business objectives and other goals. TikTok is operated in the United States by TikTok Inc., an American company incorporated and headquartered in California. TikTok Inc.'s ultimate parent company is ByteDance Limited, a privately held company that has operations in China. ByteDance Limited owns TikTok's proprietary algorithm, which is developed and maintained in China. The company is also responsible for developing portions of the source code that runs the TikTok platform. ByteDance Limited is subject to Chinese laws that require it to assist or cooperate with the Chinese government's intelligence work and to ensure that the Chinese government has the power to access and control private data the company holds. Section B, subsection 1. In recent years, U.S. government officials have taken repeated actions to address national security concerns regarding the relationship between China and TikTok. In August 2020, President Trump issued an executive order finding that the spread in the United States of mobile applications developed and owned by companies in China continues to threaten the national security, foreign policy, and economy of the United States. President Trump determined that TikTok raised particular concerns, noting that the platform automatically captures vast swaths of information from its users and is susceptible to being used to further the interests of the Chinese government. The president invoked his authority under the International Emergency Economic Powers Act, 50 U.S.C. Section 1701, and the National Emergencies Act, 50 U.S.C. Section 1601, to prohibit certain transactions involving ByteDance Limited or its subsidiaries as identified by the Secretary of Commerce. The Secretary published a list of prohibited transactions in September 2020. But federal courts enjoined the prohibitions before they took effect, finding that they exceeded the executive branch's authority under IEEPA. Just days after issuing his initial executive order, President Trump ordered ByteDance Limited to divest all interests and rights in any property used to enable or support ByteDance's operation of the TikTok application in the United States, along with any data obtained or derived from U.S. TikTok users. ByteDance Limited and TikTok Inc. filed suit in the D.C. Circuit challenging the constitutionality of the order. In February 2021, the D.C. Circuit placed the case in abeyance to permit the Biden administration to review the matter and enable the parties to negotiate a non-divestiture remedy that would address the government's national security concerns. Throughout 2021 and 2022, ByteDance Limited negotiated with executive branch officials to develop a national security agreement that would resolve those concerns. Executive branch officials ultimately determined, however, that ByteDance Limited's proposed agreement did not adequately mitigate the risks posed to U.S. national security interests. Negotiations stalled and the parties never finalized an agreement. Subsection 2. Against that backdrop, Congress enacted the Protecting Americans from Foreign Adversary-Controlled Applications Act. The act makes it unlawful for any entity to provide certain services to distribute, maintain, or update a foreign adversary-controlled application in the United States. Entities that violate this prohibition are subject to civil enforcement actions and hefty monetary penalties. See Sections 2D1A and 2D2B. The Act provides two means by which an application may be designated a foreign adversary-controlled application. First, the Act expressly designates any application that is operated directly or indirectly by ByteDance Limited or TikTok, or any subsidiary or successor thereof. Second, the Act establishes a general designation framework for any application that is both 1. Operated by a covered company that is controlled by a foreign adversary, and 2. Determined by the President to present a significant threat to the national security of the United States following a public notice and reporting process. In broad terms, the Act defines a covered company to include a company that operates an application that enables users to generate, share, and view content and has more than 1 million monthly active users. The Act excludes from that definition a company that operates an application whose primary purpose is to allow users to post product reviews, business reviews, or travel information and reviews. The Act's prohibitions take effect 270 days after an application is designated a foreign adversary-controlled application. Because the Act itself designates applications operated by ByteDance Limited and TikTok, prohibitions as to those applications take effect 270 days after the Act's enactment, January 19, 2025. The Act exempts a foreign adversary-controlled application from the prohibitions if the application undergoes a qualified divestiture. A qualified divestiture is one that the President determines will result in the application no longer being controlled by a foreign adversary. The President must further determine that the divestiture precludes the establishment or maintenance of any operational relationship between the United States operations of the application and any formally affiliated entities that are controlled by a foreign adversary, including any cooperation with respect to the operation of a content recommendation algorithm or an agreement with respect to data sharing. The Act permits the President to grant a one-time extension of no more than 90 days with respect to the prohibition's 270-day effective date if the President makes certain certifications to Congress regarding progress towards a qualified divestiture. Part C. Section C. ByteDance Limited and TikTok Inc., along with two sets of TikTok users and creators, filed petitions for review in the D.C. Circuit challenging the constitutionality of the Act. As relevant here, petitioners argued that the Act's prohibitions, TikTok-specific foreign adversary-controlled application designation, and divestiture requirement violate the First Amendment. The D.C. Circuit consolidated and denied the petitions, holding that the Act does not violate petitioners' First Amendment rights. After first concluding that the Act was subject to heightened scrutiny under the First Amendment, the court assumed without deciding that strict rather than intermediate scrutiny applied. The court held that the Act satisfied that standard, finding that the government's national security justifications countering China's data collection and covert content manipulation efforts were compelling and that the Act was narrowly tailored to further those interests. Chief Judge Srinivasan concurred in part and in the judgment. In his view, the Act was subject to intermediate scrutiny and was constitutional under that standard. We granted certiorari to determine whether the Act as applied to petitioners violates the First Amendment. We granted certiorari to decide whether the Act as applied to petitioners violates the First Amendment. Part 2, Section A. At the threshold, we consider whether the challenged provisions are subject to First Amendment scrutiny. Laws that directly regulate expressive conduct can, but do not necessarily, trigger such review. See RAV versus St. Paul. We have also applied First Amendment scrutiny in cases involving governmental regulation of conduct that has an expressive element, and to some statutes which, although directed at activity with no expressive component, impose a disproportionate burden upon those engaged in protected First Amendment activities. It is not clear that the Act itself directly regulates protected expressive activity or conduct with an expressive component. Indeed, the Act does not regulate the creator petitioners at all, and it directly regulates ByteDance Limited and TikTok Inc. only through the divestiture requirement. See Section 2C1. Petitioners, for their part, have not identified any case in which this court has treated a regulation of corporate control as a direct regulation of expressive activity or semi-expressive conduct. We hesitate to break that new ground in this unique case. In any event, petitioners' arguments more closely approximate a claim that the Act's prohibitions, TikTok-specific designation, and divestiture requirement impose a disproportionate burden upon their First Amendment activities. Petitioners assert, and the government does not contest, that because it is commercially infeasible for TikTok to be divested within the Act's 270-day timeframe, the Act effectively bans TikTok in the United States. Petitioners argue that such a ban will burden various First Amendment activities, including content moderation, content generation, access to a distinct medium for expression, association with another speaker or preferred editor, and receipt of information and ideas. We have recognized a number of these asserted First Amendment interests. C. Moody versus NetChoice LLC, City of Ladue versus Gileo, Runsfeld versus Forum for Academic and Institutional Rights Incorporated, and Martin versus City of Struthers. Footnote 2. To the extent that ByteDance Limited's asserted expressive activity occurs abroad, that activity is not protected by the First Amendment. Carrying on. An effective ban on a social media platform with 170 million US users certainly burdens those users' expressive activity in a non-trivial way. At the same time, a law targeting a foreign adversary's control over a communications platform is in many ways different in kind from the regulations of non-expressive activity that we have subjected to First Amendment scrutiny. Those differences, the act's focus on a foreign government, the congressionally determined adversary relationship between the foreign government and the United States, and the causal steps between the regulations and the alleged burden on protected speech, may impact whether First Amendment scrutiny applies. This court has not articulated a clear framework for determining whether a regulation of non-expressive activity that disproportionately burdens those engaged in expressive activity triggers heightened review. We need not do so here. We assume, without deciding, that the challenged provisions fall within this category and are subject to First Amendment scrutiny. Section B, subsection 1. At the heart of the First Amendment lies the principle that each person should decide for himself or herself the ideas and beliefs deserving of expression, consideration, and adherence. Government action that suppresses speech because of its message contravenes this essential right. Content-based laws, those that target speech based on its communicative content, are presumptively unconstitutional and may be justified only if the government proves that they are narrowly tailored to serve compelling state interests. Content-neutral laws, in contrast, are subject to an intermediate level of scrutiny because in most cases they pose a less substantial risk of excising certain ideas or viewpoints from the public dialogue. Under that standard, we will sustain a content-neutral law if it advances important governmental interests unrelated to the suppression of free speech and does not burden substantially more speech than necessary to further those interests. We have identified two forms of content-based speech regulation. First, a law is content-based on its face if it applies to particular speech because of the topic discussed or the idea or message expressed. Second, a facially content-neutral law is nonetheless treated as a content-based regulation of speech if it cannot be justified without reference to the content of the regulated speech, or was adopted by the government because of disagreement with the message the speech conveys. As applied to petitioners, the challenged provisions are facially content-neutral and are justified by a content-neutral rationale. Subsection A. The challenged provisions are facially content-neutral. They impose TikTok-specific prohibitions due to a foreign adversary's control over the platform and make divestiture a prerequisite for the platform's continued operation in the United States. They do not target particular speech based upon its content. Contrast, for example, Kerry versus Brown. Or regulate speech based on its function or purpose. Contrast, for example, Holder versus Humanitarian Law Project. Nor do they impose a restriction, penalty, or burden by reason of content on TikTok, a conclusion confirmed by the fact that the petitioners cannot avoid or mitigate the effects of the act by altering their speech. As to petitioners, the act does not facially regulate particular speech because of the topic discussed or the idea or message expressed. Petitioners argue that the act is content-based on its face because it excludes from the definition of covered company any company that operates an application whose primary purpose is to allow users to post product reviews, business reviews, or travel information and reviews. We need not decide whether that exclusion is content-based. The question before the court is whether the act violates the First Amendment as applied to petitioners. To answer that question, we look to the provisions of the act that give rise to the effective TikTok ban that petitioners argue burdens their First Amendment rights. The exclusion for certain review platforms, however, applies only to the general framework for designating applications controlled by covered companies, not to the TikTok-specific designation. As such, the exclusion is not within the scope of petitioner's as-applied challenge. Subsection B. The government also supports the challenged provisions with a content-neutral justification, preventing China from collecting vast amounts of sensitive data from 170 million US TikTok users. That rationale is decidedly content agnostic. It neither references the content of speech on TikTok nor reflects disagreement with the message such speech conveys. Because the data collection justification reflects a purpose unrelated to the content of expression, it is content neutral. Subsection 2. The Act's TikTok-specific designations, moreover, do not trigger strict scrutiny. It is true that speech restrictions based on the identity of the speaker are all too often simply a means to control content. For that reason, regulations that discriminate among media or among different speakers within a single medium often present serious First Amendment concerns. While laws favoring some speakers over others demand strict scrutiny when the legislature's speaker preference reflects a content preference, such scrutiny is unwarranted when the differential treatment is justified by some special characteristic of the particular speaker being regulated. For the reasons we have explained, requiring divestiture for the purpose of preventing a foreign adversary from accessing the sensitive data of 170 million US TikTok users is not a subtle means of exercising a content preference. The prohibitions, TikTok-specific designation, and divestiture requirement regulate TikTok based on a content-neutral data collection interest, and TikTok has special characteristics, a foreign adversary's ability to leverage its control over the platform to collect vast amounts of personal data from 170 million US users, that justify this differential treatment. Speaker distinctions of this nature are not presumed invalid under the First Amendment. While we find that differential treatment was justified here, however, we emphasize the inherent narrowness of our holding. Data collection and analysis is a common practice in this digital age, but TikTok's scale and susceptibility to foreign adversary control, together with the vast swaths of sensitive data the platform collects, justify differential treatment to address the government's national security concerns. A law targeting any other speaker would by necessity entail a distinct inquiry and separate considerations. On this understanding, we cannot accept petitioners' call for strict scrutiny, no more than intermediate scrutiny is in order. Section C. As applied to petitioners, the Act satisfies intermediate scrutiny. The challenged provisions further an important government interest unrelated to the suppression of free expression and do not burden substantially more speech than necessary to further that interest. The challenged provisions further an important government interest unrelated to the suppression of free expression and do not burden substantially more speech than necessary to further that interest. Footnote 3. Our holding and analysis are based on the public record without reference to the classified evidence the government filed below. Carrying on. Subsection 1. The Act's prohibitions and divestiture requirement are designed to prevent China, a designated foreign adversary, from leveraging its control over ByteDance Limited to capture the personal data of US TikTok users. This objective qualifies as an important government interest under intermediate scrutiny. Petitioners do not dispute that the government has an important and well-grounded interest in preventing China from collecting the personal data of tens of millions of US TikTok users, nor could they. The platform collects extensive personal information from and about its users. If, for example, a user allows TikTok to access the user's phone contact list to connect with others on the platform, TikTok can access any data stored in the user's contact list, including names, contact information, contact photos, job titles, and notes. Access to such detailed information about US users, the government worries, may enable China to track the locations of federal employees and contractors, build dossiers of personal information for blackmail, and conduct corporate espionage. And Chinese law enables China to require companies to surrender data to the government, making companies headquartered there an espionage tool of China. Rather than meaningfully dispute the scope of the data TikTok collects or the ends to which it may be used, Petitioners contest probability, asserting that it is unlikely that China would compel TikTok to turn over user data for intelligence gathering purposes since China has more effective and efficient means of obtaining relevant information. In reviewing the constitutionality of the act, however, we must accord substantial deference to the predictive judgments of Congress. Sound policymaking often requires legislators to forecast future events and to anticipate the likely impact of these events based on deductions and inferences for which complete empirical support may be unavailable. Here, the government's TikTok related data collection concerns do not exist in isolation. The record reflects that China has engaged in extensive and years long efforts to accumulate structured datasets, in particular on U.S. persons, to support its intelligence and counterintelligence operations. Even if China has not yet leveraged its relationship with ByteDance Limited to access U.S. TikTok users' data, petitioners offer no basis for concluding that the government's determination that China might do so is not at least a reasonable inference based on substantial evidence. We are mindful that this law arises in a context in which national security and foreign policy concerns arise in connection with efforts to confront evolving threats in an area where more information can be difficult to obtain and the impact of certain conduct difficult to assess. We thus afford the government's informed judgment substantial respect here. Petitioners further argue that the act is under-inclusive as to the government's data protection concern, raising doubts as to whether the government is actually pursuing that interest. In particular, petitioners argue that the act's focus on applications with user-generated and user-shared content, along with its exclusion for certain review platforms, exempts from regulation applications that are as capable as TikTok of collecting Americans' data. But the First Amendment imposes no freestanding under-inclusiveness limitation, and the government need not address all aspects of a problem in one fell swoop. Furthermore, as we have already concluded, the government had good reason to single out TikTok for special treatment. Contrast Brown versus Entertainment Merchants Association. On this record, Congress was justified in specifically addressing its TikTok-related national security concerns. Subsection 2. As applied to petitioners, the Act is sufficiently tailored to address the government's interest in preventing a foreign adversary from collecting vast swaths of sensitive data about the 170 million U.S. persons who use TikTok. To survive intermediate scrutiny, a regulation need not be the least speech-restrictive means of advancing the government's interests. Rather, the standard is satisfied so long as the regulation promotes a substantial government interest that would be achieved less effectively absent the regulation and does not burden substantially more speech than is necessary to further that interest. The challenged provisions meet this standard. The provisions clearly serve the government's data collection interest in a direct and effective way. The prohibitions account for the fact that, absent a qualified divestiture, TikTok's very operation in the United States implicates the government's data collection concerns, while the requirements that make a divestiture qualified ensure that those concerns are addressed before TikTok resumes U.S. operations. Neither the prohibitions nor the divestiture requirement, moreover, is substantially broader than necessary to achieve this national security objective. Rather than ban TikTok outright, the Act imposes a conditional ban. The prohibitions prevent China from gathering data from U.S. TikTok users unless and until a qualified divestiture severs China's control. Petitioners parade a series of alternatives: disclosure requirements, data sharing restrictions, the proposed national security agreement, the general designation provision, that they assert would address the government's data collection interest in equal measure to a conditional TikTok ban. These alternatives do not alter our tailoring analysis. Petitioners' proposed alternatives ignore the latitude we afford the government to design regulatory solutions to address content-neutral interests. So long as the means chosen are not substantially broader than necessary to achieve the government's interest, the regulation will not be invalid simply because a court concludes that the government's interest could be adequately served by some less speech-restrictive alternative. For the reasons we have explained, the challenged provisions are not substantially broader than necessary to address the government's data collection concerns, nor did the government ignore less restrictive approaches already proven effective. Contrast McCullen versus Coakley. The validity of the challenged provisions does not turn on whether we agree with the government's conclusion that its chosen regulatory path is best or most appropriate. We cannot displace the government's judgment respecting content-neutral regulations with our own so long as its policy is grounded on reasonable factual findings supported by evidence that is substantial for a legislative determination. Those requirements are met here. Section D. In addition to the data collection concerns addressed above, the government asserts an interest in preventing a foreign adversary from having control over the recommendation algorithm that runs a widely used U.S. communications platform and from being able to wield that control to alter the content on the platform in an undetectable manner. In petitioner's view, that rationale is a content-based justification that taints the government's data collection interest and triggers strict scrutiny. Petitioners have not pointed to any case in which this court has assessed the appropriate level of First Amendment scrutiny for an act of Congress justified on both content-neutral and content-based grounds. They assert, however, that the challenged provisions are subject to and fail strict scrutiny because Congress would not have passed the provisions absent the foreign adversary control rationale. We need not determine the proper standard for mixed justification cases or decide whether the government's foreign adversary control justification is content neutral. Even assuming that rationale turns on content, petitioner's argument fails under the counterfactual analysis they propose. The record before us adequately supports the conclusion that Congress would have passed the challenged provisions based on the data collection justification alone. To start, the House report focuses overwhelmingly on the government's data collection concerns, noting the breadth of TikTok's data collection, the difficulty in assessing precisely which categories of data the platform collects, the tight interlinkages between TikTok and the Chinese government, and the Chinese government's ability to coerce companies in China to provide data. Indeed, it does not appear that any legislator disputed the national security risks associated with TikTok's data collection practices, and nothing in the legislative record suggests that data collection was anything but an overriding congressional concern. We are especially wary of parsing Congress's motives on this record with regard to an act passed with striking bipartisan support. Petitioners assert that the text of the act itself undermines this conclusion. In particular, they argue that the government's data collection rationale cannot justify the requirement that a qualified divestiture preclude any operational relationship that allows for cooperation with respect to the operation of a content recommendation algorithm or an agreement with respect to data sharing. We disagree. The government has explained that ByteDance Limited uses the data it collects to train the TikTok recommendation algorithm, which is developed and maintained in China. According to the government, ByteDance Limited has previously declined to agree to stop collecting U.S. user data or sending that data to China to train the algorithm. The government has further noted the difficulties associated with monitoring data sharing between ByteDance Limited and TikTok Inc. Under these circumstances, we find the government's data collection justification sufficient to sustain the challenged provisions. There is no doubt that, for more than 170 million Americans, TikTok offers a distinctive and expansive outlet for expression, means of engagement, and source of community. But Congress has determined that divestiture is necessary to address its well-supported national security concerns regarding TikTok's data collection practices and relationship with a foreign adversary. For the foregoing reasons, we conclude that the challenged provisions do not violate petitioners' First Amendment rights. The judgment of the United States Court of Appeals for the District of Columbia Circuit is affirmed. It is so ordered. Justice Sotomayor concurring in part and concurring in the judgment. I join all but Part 2A of the Court's per curiam opinion. I see no reason to assume without deciding that the Act implicates the First Amendment because our precedent leaves no doubt that it does. TikTok engages in expressive activity by compiling and curating material on its platform. Laws that impose a disproportionate burden upon those engaged in expressive activity are subject to heightened scrutiny under the First Amendment. The challenged act plainly imposes such a burden. It bars any entity from distributing TikTok's speech in the United States unless TikTok undergoes a qualified divestiture. The act, moreover, effectively prohibits TikTok from collaborating with certain entities regarding its content recommendation algorithm, even following a qualified divestiture. And the act implicates content creators' right to associate with their preferred publisher for the purpose of speaking. That, too, calls for First Amendment scrutiny. As to the remainder of the per curiam opinion, I agree that the act survives petitioner's First Amendment challenge. Justice Gorsuch concurring in the judgment. We have had a fortnight to resolve, finally, and on the merits, a major First Amendment dispute affecting more than 170 million Americans. Briefing finished on January 3rd, argument took place on January 10th, and our opinions issue on January 17th, 2025. Given those conditions, I can sketch out only a few and admittedly tentative observations. First, the court rightly refrains from endorsing the government's asserted interest in preventing the covert manipulation of content as a justification for the law before us. One man's covert content manipulation is another's editorial discretion. Journalists, publishers, and speakers of all kinds routinely make less than transparent judgments about what stories to tell and how to tell them. Without question, the First Amendment has much to say about the right to make those choices. It makes no difference that Americans like TikTok Inc. and many of its users may wish to make decisions about what they say in concert with a foreign adversary. Those who won our independence knew the vital importance of the freedom to think as you will and to speak as you think, as well as the dangers that come with repressing the free flow of ideas. They knew, too, that except in the most extreme situations, the fitting remedy for evil counsels is good ones. Too often in recent years, the government has sought to censor disfavored speech online as if the internet were somehow exempt from the full sweep of the First Amendment. See, for example, Murphy versus Missouri. But even as times and technologies change, the principle of the right to free speech is always the same. Second, I am pleased that the court declines to consider the classified evidence the government has submitted to us, but shielded from petitioners and their counsel. Efforts to inject secret evidence into judicial proceedings present obvious constitutional concerns. Usually, the evidence used to prove the government's case must be disclosed to the individual so that he has an opportunity to show that it is untrue. Maybe there is a way to handle classified evidence that would afford a similar opportunity in cases like these. Maybe, too, Congress or even the Standing Committee on Rules of Practice and Procedure would profit from considering the question. But as the court recognizes, we have no business considering the government's secret evidence here. Third, I harbor serious reservations about whether the law before us is content neutral and thus escapes strict scrutiny. More than that, while I do not doubt that the various tiers of scrutiny discussed in our case law, rational basis, strict scrutiny, some things in between, can help focus our analysis, I worry that litigation over them can sometimes take on a life of its own and do more to obscure than to clarify the ultimate constitutional questions. Fourth, whatever the appropriate tier of scrutiny, I am persuaded that the law before us seeks to serve a compelling interest, preventing a foreign country designated by Congress and the President as an adversary to our nation from harvesting vast troves of personal information about tens of millions of Americans. The record before us establishes that TikTok mines data both from TikTok users and about millions of others who do not consent to share their information. According to the Federal Bureau of Investigation, TikTok can access any data stored in a consenting user's contact list, including names, photos, and other personal information about unconsenting third parties. And because the record shows that the People's Republic of China can require TikTok's parent company to cooperate with its efforts to obtain personal data, there is little to stop all that information from ending up in the hands of a designated foreign adversary. The PRC may then use that information to build dossiers for blackmail, conduct corporate espionage, or advance intelligence operations. To be sure, assessing exactly what a foreign adversary may do in the future implicates delicate and complex judgments about foreign affairs and requires large elements of prophecy. But the record the government has amassed in these cases after years of study supplies compelling reason for concern. Finally, the law before us also appears appropriately tailored to the problem it seeks to address. Without doubt, the remedy Congress and the President chose here is dramatic. The law may require TikTok's parent company to divest or effectively shutter its U.S. operations. But before seeking to impose that remedy, the coordinate branches spent years in negotiation with TikTok exploring alternatives and ultimately found them wanting. And from what I can glean from the record, that judgment was well founded. Consider some of the alternatives. Start with our usual and preferred remedy under the First Amendment, more speech. However helpful that might be, the record shows that warning users of the risks associated with giving their data to a foreign adversary controlled application would do nothing to protect non users' data. Forbidding TikTok's domestic operations from sending sensitive data abroad might seem another option. But even if Congress were to impose serious criminal penalties on domestic TikTok employees who violate a data sharing ban, the record suggests that would do little to deter the PRC from exploiting TikTok to steal Americans' data. The record also indicates that the size and complexity of TikTok's underlying software may make it impossible for law enforcement to detect violations. Even setting all these challenges aside, any new compliance regime could raise separate constitutional concerns, for instance, by requiring the government to surveil Americans' data to ensure that it isn't illicitly flowing overseas. Whether this law will succeed in achieving its ends, I do not know. A determined foreign adversary may just seek to replace one lost surveillance application with another. As time passes and threats evolve, less dramatic and more effective solutions may emerge. Even what may happen next to TikTok remains unclear. But the question we face today is not the law's wisdom, only its constitutionality. Given just a handful of days after oral argument to issue an opinion, I cannot profess the kind of certainty I would like to have about the arguments and record before us. All I can say is that at this time and under these constraints, the problem appears real and the response to it not unconstitutional. As persuaded as I am of the wisdom of Justice Brandeis in Whitney and Justice Holmes in Abrams, their cases are not ours. Speaking with and in favor of a foreign adversary is one thing. Allowing a foreign adversary to spy on Americans is another. And that concludes the reading of the opinions in TikTok versus Garland. So, this case is significantly more complicated and difficult than the cases that we've read up to now, at least in my mind. And that's sort of in part a consequence of what I perceive to be kind of a confused and inconsistent jurisprudence on the First Amendment for reasons that we'll get to later. But yeah, this one's not as straightforward, and I'm still not entirely sure exactly what the correct answer should be. I was definitely, I listened to the oral arguments in this case. Um, back when it was before the Supreme Court and before the opinion and whatnot, and um, I was very much, of the opinion that, like, yes, this implicates the First Amendment and probably violates it. Uh, Certainly before the oral arguments, I believe I remember being of the same opinion, although maybe a little less strongly, after the oral arguments. Um, but, yeah, I think the majorities or not the majority, the main opinions analysis is mostly fine, mostly good. I agree with Justice Sotomayor and Justice Gorsuch that the court doesn't need to assume without deciding that this law implicates the First Amendment. It definitely does. Um, as Justice Gorsuch points out, it talks about or, prohibits certain like content moderation or content quote unquote manipulation. Um, and, yeah, that's just not something the government has any business, prohibiting or anything that the government has any business, um, putting forward as an interest that it has in its legislation. That's not a permissible interest that, under the First Amendment, right? Um, as Justice Gorsuch points out, like, one person's content manipulation is another person's editorial discretion, and that is fundamentally, First Amendment protected conduct. That said, I think, uh, Justice Gorsuch is correct that whether you choose strict scrutiny or intermediate scrutiny, the challenged regulation probably survives. Um, Obviously, with respect to intermediate scrutiny, probably with respect to strict scrutiny, right? Because strict scrutiny is more demanding. It's how tiered levels of scrutiny work. Um, but I also I also like his point about the tiered levels of scrutiny. It's sort of besides the point in this case, but I do like that he points it out, that litigation over, like, what level of scrutiny to apply and what each level of scrutiny requires and whatnot, becomes very confused very quickly, and this is one of the things I don't really like about, this whole framework of, like, tiered scrutiny, is that, as I sort of mentioned at the outset, it tends to produce a kind of confused and inconsistent, and very policy laden sometimes, jurisprudence. And it's, another thing that I dislike is that it's entirely atextual. It doesn't come from the Constitution anywhere. Not even so much as like implied anywhere. It's just kind of entirely a judge-made doctrine, and, I share, Justice Gorsuch and other justices on the court, skepticism about judge-made doctrines, and so I am while I am pretty well convinced that the law probably survives whatever level of scrutiny you wanna use to assess it, um, I'm not entirely sure whether or not it survives, First Amendment analysis, under, a different sort of framework, and I don't know exactly what that framework, uh, would be. Maybe you still look to these tiered levels of scrutiny as like, uh, I don't know, as sort of as Justice Gorsuch says, like focusing your analysis or helping to guide your analysis or whatever, but, um yeah, the ultimate question, right, is does it violate the text, of the First Amendment and the meaning of the text of the First Amendment? And this, framework of, like, tiered scrutiny doesn't come from the text of the First Amendment, so I'm not entirely sure what that analysis might look like or what it would mean for this law, but under the First Amendment analysis, as it exists in the Supreme Court's jurisprudence, yeah, this law is probably constitutional. And aside from that, I also did like Justice Gorsuch's point about not considering confidential evidence. The fact that the court did not consider confidential evidence here is a very good thing. Because if the court is considering evidence that only the government gets to see, only the government gets to put forward, the other side doesn't get to rebut, doesn't even get to see, um, that's a problem, and I believe I remember at oral arguments, Justice Gorsuch, like, asking the advocates questions about this and, like, "Hey, could you not have presented this, this confidential evidence in, some other manner that would have allowed, opposing counsel to, like, see it and do anything about it?" Um, and yeah, the government seemed sort of reluctant to, accept that sort of thing, but, yeah, I think if the government is putting forward confidential evidence, the court just shouldn't consider it, um, and if the government wants that evidence considered, it has to somehow, present it to opposing counsel, so Once again, finding myself agreeing quite a lot with Justice Gorsuch. That will probably be a common theme throughout these episodes. So if you're not a huge fan of Justice Gorsuch, sorry. But you might not be a huge fan of my analysis either. Well, analysis, my opinions. It is worth noting, I'm recording this in uh, late 2025, and as far as I'm aware, this law just has not been enforced. That President Trump, I believe, has granted illegal, unlawful extensions to TikTok, if I remember correctly, multiple times. Um, and yeah, the law just isn't being enforced as far as I'm aware. Yeah, I'm not a TikTok user and haven't been following developments on this after the Supreme Court's opinion all that closely, but yeah, as far as I'm aware, TikTok is just available in the United States still. Has not divested ownership, has not, gone through any of the things that it's supposed to go through in order to be exempted from this law, and yeah, it's just kind of as if nothing really happened for some reason. But yeah, I think that's about it. So, if I may ask you, my friends on the other side of the screen, please like, share, comment, follow the podcast wherever it is you follow podcasts. And if you'd like to support the podcast, you can do it on Patreon. The main content of the show will, of course, always remain free, but Patreon members can get access to episodes early, as well as any bonus or exclusive content, and they can request specific content, including other than reading Supreme Court opinions. With that, tune in for the next episode where we will continue our trek through the Supreme Court's 2024 term. Until then.